The race for Mbale woman MP seat was hotly contested, mainly between Lydia Wanyoto and Connie Galiwango, the incumbent. Galiwango garnered 40,500 votes against 25,700 votes for Lydia Wanyoto. However, in March, Lydia Wanyoto filed a petition in Mbale High Court challenging the outcome of the election, citing several failures by the Electoral Commission. Wanyoto shared what it takes to file a petition.
My electoral area is big. These are 12 sub-counties. You cannot walk there. So you have to have transport moving up and down of agents. And the second issue, which is also very important, is to, of course, get the law, unpack the law. There are many electoral laws and also authorities. That's a lot of work. So you needed a team of researchers to do that work. And that also costs money and time. But also most important is to keep some people have challenges, but to keep the witnesses firm.
Besides legal costs involved, Wanyoto is prepared to foot the bills when the court asks for witnesses.
In many of my areas, some of my witnesses or my agents were holiday makers. Schools have opened. So as I wait for the trial, if they ask for them, we'll have to write to the schools, and maybe my case might be far from where they go to school, so you have to transport them to come.
The former Uganda Law Society President Francis Gimara listed some of the grounds that a petitioner must consider before filing a petition.
Situations where a returning officer wakes up and violates every known provision of the law. Instead of declaring candidate A, they declare candidate B. And if you can lead evidence to that, that election will be invalidated. The third one is really that an illegal practice was committed. I'll give an example of bribery. If you can lead evidence that indeed this candidate or the agents of that candidate, with their knowledge, that's also the other aspect, with their knowledge did bribe, then that would be another ground for invalidating the election. Then also the other fourth ground is that at the time of election, the person who was elected was either not qualified or had been disqualified.
There are some instances where petitioners accuse their opponents of ballot stuffing, something that is very hard to prove in an election, where agents were not allowed to use phones.
It can't be that you have said it is ballot stuffing, and that is it. You have got to corroborate that evidence in a substantial manner. And also, I've told you that the court takes the view that the witnesses you bring are really your supporters. They are as aggrieved as you.
A lost petition costs between 30 to 150 million shillings. According to Gimara, there is one mistake that almost every petitioner makes.
People think about petitions after the elections. Okay? You need to think about your petition before, from day one when you're a candidate. Understand the legal framework under which that election is being conducted, and document all the wrongs that you see and their implications.
All in all, if you know that you participated or contested for MP seat in the previously concluded elections, you have a right to contest or challenge the outcome, especially if you know you have evidence in form of affidavits, pictorial, visual, and also audio, since the previous election was conducted in a scientific manner. But one thing you must bear in mind, that if your petition does not hold water, or if you lose it, then you must be ready to part with astronomical sums of money to pay whoever you're trying to challenge. And that will also depend on how your legal team is going to tussle it out in court. Sudhili Yaruhanga, NTV.